Hi, so here we are again. It's me for the next lecture we've got together in land law. So, first lecture established the extent to which land is relevant in land law. So, how far up and down are we going? What comes with a parcel of land? The things that are affixed to it, and or then chattels or fittings that we aren't as bothered by and can be movable. Now we're starting to develop the idea further surrounding land law and thinking about estates first. We'll be moving on then next week to interests in land, and hopefully all of this will start to build a foundation and a picture of land law. But obviously we've got a seminar next week to fully develop your understanding of this and make sure that you're grounded in it. So what I want to do is kind of tell you some context first, because the situation that we're in now, as I've spoken to you about previously with the end of the previous lecture, the situation we're in now is formed by that which has gone before. So we have to understand a little bit about the history of this country in understanding what the idea of an estate is trying to deal with. So the idea of an estate is trying to work around the fact that in the UK there is no ability to own the land itself. So once you remove that notion of ownership from your head, you're left with a gaping hole, and then landlord has to step in and create some artifice or construct something that will fit around how then can you hold property, because if you aren't able to own it, how can we recognize your hold on it? So all of this is deeply rooted in history, unfortunately. It's not something that you're going to need to get to grips with too much, but it's important then to understand why in the UK there would never be such a thing as a true owner. So we'll deal with the historical context. We'll look at tenure, which was the previous way of holding land, and then moving on to estates, and then what estates have meant since the Law of Property Act came into effect on the 1st of January 1926. So we had a raft of legislation in 1925 enacted and then coming into effect in 1926. And then we'll look at very briefly what sort of formalities those legal estates might need. It's not something I want to labour today. If you feel that we've addressed it too quickly, please don't stress. We will be returning to it when we look at formalities in more detail next week. So that's the outline for the session. So previously, if you're thinking about tenure and what it meant to hold land prior to more modern concepts of land holding, we have to kind of go back to when this country was invaded really in 1066 and taken. And that taking of all the land meant that the king, the invading king, had all land as a possession. And then it was for the king to allow those in favour or those who had in need of reward would be given pieces of land or plots of land. So the king would allow the person that the gift was passing to hold the land in return for services. So not a true gift, not as if I gave you a watch or I gave you a car with an unconditional approach to it, that you could keep the car or you could keep the watch. Any gift of land from the king was very much subject to your behaviours, your services, your return of whatever the king might want from you. So that whole idea of tenure was a holding. So that's where the verb comes from. You know, tenuous, holding. You know, to hold height to something, tenare. So the king would allow you to hold on to it in return for those behaviours, services, daughters, goats, fighting in wars, whatever it was that the king wanted of you in the time. There would be effective kind of people left to run the place. Usually the lord of a manor would be some form of sitting tenant. We'd have maybe middle owners or lords, main lords they were known as. It's where kind of we get domain. So this was a very feudal system. It was based on the fact that you were holding on to something. It was hierarchical with, if you think of a pyramid with the king at the top, and then various levels of management and micromanagement or holdings underneath. And obviously, in a more modern society, in a more democratic society, that has to change because it's not all beholden to the king in terms of just an ability to hold on to land. That very flexible and subjective approach to land use and possession isn't appropriate in a modern democratic society. So moving forward from that, we're still always left with the legacy of crown ownership. The crown retain ownership of all the land. There can be no ability to maneuver past that. The crown retain, Liz in all her infinite wisdom still retains all land in the UK. And all therefore we are entitled to is some recognition of our own specific hold. So that's where the estate comes from. The idea of an estate in land was there to recognise this hold that you could have over land. And we had many, really, but the idea of a fee simple estate, or the idea of estate in time, really, came from the case of Walsingham in 1573. We get almost a space style or a time and space notion of this idea of land that isn't just the physical touch or the thing we're on, but how long we're there for. So this idea of a time concept came about. The phrase being the court defining an estate and land as a time in the land or land for a time, and there are diversities of estates which are no more than diversities of time. For he who has a fee simple in land has a time in the land without end, or the land for a time without end. And he who has land in tail has a time in the land, or the land for time as long as he has issue of his body. So this recognizes this ability to be on the land for time, and that time carrying on when you're no longer there. So like a fee simple that you could pass on to somebody else, or a fee tail, that the tail drops effectively when you die. So that's where our legacy of estates begins. The idea of, yes, we hold it, we're in possession of it, but our possession and our hold is very time dependent. So before 1926, we would see many types of estate, and I'm going to take you to the list that's on page 7 of your week 1 lecture notes, which are on Canvas, but for ease I'm just going to take you to there for a moment. So we'll see that we had freehold estates that could be a life estate, a fee tail, a fee simple, and also leasehold estates, and a few different types of those as well within leaseholding. Complicated, very difficult to know who had what, reliant on documentary evidence that may or may not be there, and the whole situation became very cumbersome. There were some that were legal, as in they had the correct formalities met, which is where we're headed soon. They would be legally identifiable and made by deed. And with some that were equitable, so they were only contractual. And that meant that it was a very confusing picture as to how long somebody really could be on the land, and then in transferring that land, what was it that was being transferred, and could it be transferred? Because if you were only allowed to stay somewhere for the rest of your life, how could that be a situation that then would be transferable to somebody else? you could keep if you were 70 and you kept transferring, it kept transferring to somebody who was 20, and then when they got to 70 they transferred it to somebody who was 20, that it would be not what was intended from the outset. So it became very complex as a system. So the Law of Property Act 1925 has attempted to address definitely the evidentiary requirements for a lot of this, but also the recognition of estates and interests. Now, under section 1.1, we only have two. So section 1, like literally the first piece of the most important property legislation, is telling us that there are only going to be two estates in land. So section 1.1, we get two estates in land. We get an estate in fee simple absolute in possession, section 1.1a. And we get section 1.1b, a term of years absolute. Now, I know when I was in Cambridge doing some seminars, I was able to break some of that down into some lay language, and that's what I'll be doing in Chelmsford tomorrow as well. So please don't stress. I'm going to talk to you about it now, but we will always be bringing this down to understandable language, which you can then look at the legislation for. So intrinsically, those two things that you're looking for would be what we would recognize as an owner, the freeholder, and the second one would be a tenant, a term of years absolute. So those two estates, the only estates in land that are now legally recognized as being capable of being legal, are the fee simple absolute in possession and a term of years absolute. Those are the only types of estates in land that we could have as legally recognizable estates. Ownership, in very, very exaggerated bunny ear quotations in the sky, because there is no real ownership, and tenancy. Everything else that is not those two things becomes equitable if it's intended to pass hold in land for a time period. So unless it's a freehold that is made by deed or a tenancy with the correct formalities, it will be equitable. Everything else, as an estate, as a way to hold yourself onto the land and call it yours in some way, will become equitable. So we've two legal estates now, and the formalities have to be met for those to become legal. Everything else could never be legal, and or if the formalities weren't met to make it legal, it would become equitable. Again, I will be doing plenty of work about this and around this in class. So first of all, the fee simple absolute in possession, as I've said, section 1.1a, so the most important first prime piece of legislation that you see is that a freehold is this idea that it is something given perpetually. So it's given pretty much forever. It can be inherited by somebody else. It can be sold on to somebody else. It is something that is granted freely, and the idea is that your hold on the land is indefinite. Obviously, if Liz wanted it back in the morning, she could take it from you, but compulsory purchase powers would mean that there would have to be some form of payment for that. So there's no condition to it. It's absolute. You have the absolute rights of ownership and possession of it. You don't have to do anything in terms of continual payment or whatever. It's yours to enjoy, and you can enjoy it straight away. So the idea being that you would possess it. Possession used to be incredibly important. That was key really in articulating your use and enjoyment of the property. If you've ever heard of adverse possession or squatting, squatting used to be very fiercely protected, because the idea was that if the true owner or the freeholder wasn't going to possess it, that somebody else would go in adversely and possess it instead of them. So that's where the notion of squatting takes hold, is that you as the true owner should be possessing it, and if you're not going to possess it, somebody else could take it from you. Very hard to do now under land registration, but previously a more simple way of taking land from somebody. So yeah, freehold, also known as, you know, in the more correct terminology, as a fee simple, absolute, and possession, and we would commonly recognise that person as the owner of the property. The second estate can only happen as a result of the first estate. So everything is held as a freehold, everything is owned, and then out of that ownership, it's possible to create a second estate. As an owner, it's possible for me to rent my property out and create a tenancy, but a tenancy cannot arise on its own. We would have to always have a freehold. So the term of years absolute is the more technical term for a leasehold. So any tenancy will be recognised in the eyes of the law under Section 11B of the Law of Property Act 1925 as a term of years absolute. That leasehold means that it's fixed in nature. So the term of years being fixed, we can see how long it's for. It can be for a number of years, obviously, but we can even have 6-month, 9-month leases. And again, that absolute nature means that it's absolutely yours to use and exclude the world at large, including the landlord, except for things that you've agreed, such as inspections, and or if you've, you know, if they have to come and get the rent from you, or they have to fix a broken tap or something like that. So you have the absolute right of possession, but it's something that is fixed in nature for a specific time period and stems from the freeholder. So it's an offshoot of somebody else's ownership. It could be in the future. So for example, as students, you may have had situations where you see a property before you go on summer holidays in May, June, and then you know you're going to come back to it in September or October. So you could have a future interest in the property. You could sign a future term of years absolute, and the best thing to do, which I'm sure no one has done, would be to go to land registry and protect that, because obviously if that landlord rented it out in the meantime, you wouldn't have any evidence, or the property was sold, you wouldn't have any evidence that that agreement existed. But if you were at land registry, you would exist to the eyes of the world. So yeah, two key estates, freehold and leasehold. They are the ones that are capable of being legal. In order to then become legal, we would have to correctly put the right legal document onto them. If that doesn't happen, they will become equitable, and or if they are not freehold or a leasehold, if they're vague in some way, if it's for somebody's life, or it's something done as a favour or kindness, it will be equitable in nature. It's never going to be legal. Okay, so that's really the stuff that I need you to comprehend. Those are the top two estates. They're always going to be prevalent in any problem question or anything that you write about. You will be dealing with a freeholder in every situation. You will have a fee simple, absolute, and possession. Section 11A, Law of Property Act 1925. We have to be able to identify and define that person or those people from the get-go, because they are the main party for all intents and purpose until we get to the bank. If there's a mortgage on the property, they're the other key player, but the freeholder is always the person that we're looking for to identify, because they're the person who's capable of passing the property over to somebody else. So back to the idea of a lease. As I've said already, the terms of the lease themselves must be certain. We will be going through this in a bit more detail when we're looking at the difference between a lease and a license, but intrinsically that idea of certainty is very important. So we're going to have to look at a case called Lace and Chandler when we get to leases and licenses, and that's a case where the period of possession was granted as being for the period of the war, as long as the war was on. Now that's not definite, that's not able to be identified. Same as if I said for the summer or the winter, when it's raining, anything like that would be vague. So as long as the war lasts, I mean, there have been very, very long wars, there have been very short wars, that isn't sufficiently a term of a lease. We would have to be very clear of a start date and an end date, or at least a 6 months from an ascertainable moment, or a year, or however many. But the term itself must be able to be identified. So for the length of the war was seen to be not sufficiently certain. Yeah, we've done that. Duration of the war, uncertain term, and it was deemed to be not valid. We did all of that. Excellent. So that is something we, as I said, we'll revisit when we get to looking at leases against licenses. But ultimately, as a person looking at this stage for estates in land, you would be looking for somebody whose freehold is given freely, that they have it indefinitely and can sell it or pass it down to somebody else, so not just for their own lifetime. And it also then would not become a lease, because again, during somebody's lifetime is not a sufficiently clear term. So that's just a heads up potentially for questions that might be coming your way. Formalities I'm going to touch on very briefly, because I ultimately want to do a lot more work with you on formalities. It's something that I see as fitting into the next phase of what we would do together. So I would like to teach estates and interests, then look at the formalities for all of those, and then look at land registration for all of those. But I'll touch upon it briefly. The formalities are listed under Section 52(1) of the Law of Property Act 1925. And any legal estate, and we know now that there are two, fee simple absolute in possession and the term of years absolute, should be made by deed. So all sales of land or the passing of any interest, any kind of estate that is legal in nature, it has to be made by deed. So if a landlord is creating a tenancy, that legal tenancy, that legal term of years absolute will be made formal by creating a deed. And a deed means it's got deed on the top of it, it's witnessed, it's signed at a solicitor's, and that will make it a validly executed legal estate. As you can tell by the brackets there, it's possible to make a legal interest too, which is why I'm going to cover this again once we've done interests. But for now, what you can know is that a deed is the thing that you need to make something legal. It might have been capable of being legal, but until you put a deed on it, it's not going to actually validly become legal. Exceptions to that, and again I will go through this with you a number of times, would be a short-term lease. So if we've got a lease that is oral in nature, or a short-term lease under 3 years, we will not need a deed. We can usually do that legally, and or we can formalize it with some other form of paperwork such as the tenancy agreement. It does not need a deed, but it will still be a legal and a legally binding lease. And there's reasons for that that will make sense when we look at land registry in more detail. Ultimately, what you're thinking about with legal estates and interests is that they're most binding. They're the best form of, if you're thinking of top trumps, so the best form of protection you could have for yourself. So the best person ever, the person with the most strength in the eyes of the law is going to be the freeholder with a deed that says that they're a freeholder, and then has put that on land registry. The next person down being the tenant, who has a tenancy effective legally by deed, or if it's under 3 years, it doesn't need the deed, but it's still a legal lease. So this kind of hierarchy begins of people that have a hold in the land, and that's why we're doing this stuff. Whenever you look at a plot of land, you're going to have to establish what the hierarchy is. You're going to have to look at that plot of land and figure out who the key players are, and the only way you can do that if you know what these requirements are, what's capable of being legal, what piece of paperwork did it need to become legal, and then did they put it at land registry to tell the world that they exist. So I hope it wasn't too whistle stop. If you felt that it went too quickly, all I can say to you is that we will be doing this again and again and again over the next few weeks, and we've got 2 other opportunities where we put it all together. Effectively, what I really need you to grasp is that there are only capable of being two legal estates in land: the fee simple absolute in possession under section 11A of the Law of Property Act, and the term of years absolute under section 11B of the Law of Property Act. Those are the only 2 estates that are capable of being legal. In order to then be legal, they will need a deed under section 52. So that's the stamp of approval that states that they have definitely been made legal. And then what we're going to do next is we're going to layer on top of that. So we've established our 2 legal estates. We're going to layer interests onto that, and then we're going to go back over formalities for all of that. So we'll be doing that. I know it seems a bit dry at the moment, lots of PowerPoint slides, lots of text. That's not my teaching style, so whenever we're doing it next, we'll be looking at plots of land and we'll be placing people so that we can start to recognise who the key players are within this. So thank you very much, and I look forward to seeing the guys at Chelmsford tomorrow and anyone online tomorrow afternoon as well. Thank you.